Hi guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Boring day, Tuesday. But gotta work today, so that'll keep me busy. We do have a Sov Cit with Judge Fish, and it's pretty damn good. Oh man, he does a great job. Here we go.
We'll see you back on the 18th of May.
9.
Oh, we'll do it at 9. That's fine. Yeah, thank you.
Thank you, Your Honor.
Thank you, sir. You put 9, didn't you? Perfect. We're adjourned. Okay. Right. Okay. For Michael Aligretti, state, would you please set a record?
Yes, State of Indiana versus Michael Aligretti, 64 D01 2509 F2 10947. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a FREDA hearing.
It is Ferretta. Mr. Aligretti wants to represent himself. Sir, did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Aligretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
and you will have
finish
counsel.
talking?
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that, Your Honor.
You are accepting it, sir. You know what direct contempt of
I
court
wanted
is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders.
You guys keep boogering up my chat over the last couple of weeks.
That struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record. Understand that, sir?
Yes.
What's your address?
7021 Square, Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Bobby, is that you? Tell me the truth. Is that you?
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago. Officer Ball, can you give him this? Sure. In that, I wanted to make sure that you were explicitly warned that, well, firstly, I'll consider this conduct during the Ferretta hearing as evidence of an inability or unwillingness to abide by the rules of procedure, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time your lawyer's filing things because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I didn't. I had some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that
Competency issues right now. Send him in. Send him in and get a whole bunch of evals and make him competent for court.
there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer though,
I just appointed a lawyer for you.
but I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sure, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
I said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that
Thank you, Brad.
I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay, so I have time that I work on cases. Everything's pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedures of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your
why?
Honor, but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in
therefore,
equity, Your
you're
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand.
I could be wrong, Brad. I really could be. But I think they are called guilds. For the bars, they're called guilds. For the bar, it's association.
The proceedings and the charges of this matter.
Okay, let's go through the charges again. I had an initial hearing with you. Let me see when I had the initial hearing. Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all three charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. You do not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28th, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be, September 28th?
Drug dealer. No key. Throw him in. Oops. We lost the key. Oops.
2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you.
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah,
I'm just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, no, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah,
I'm required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand
want-
you
I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No, 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 no. I already appointed a court-appointed attorney for you because you can't get through the
He was traveling the coke. Might go. Traveling.
Feretta hearing. You understand why you can't get through the Feretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in propria persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear. Because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body, and I'm a living human
What does
being.
it mean, sir?
Are you here to practice court? Are you? I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here.
He shot his shot with his script and messed it all up. We all know the script here. We all know what you were supposed to say. You are poor Sov Cit, sir.
With your sovereign citizen
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
And
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
What's your statement?
Why is that so hard to?
Because the first part of your statement, this is a Feretta hearing. I'm here for a Feretta hearing. I've already denied your Feretta rights based on the very first words that came out of your mouth, which was that you're not willing to subject yourself to the jurisdiction of the court. If you're not willing to subject yourself to the jurisdiction of the court, you're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it.
But sir, his social security number is on the dark web. So you have to let him do whatever he wants.
So I'm appointed counsel for you. I was going through the charges in count one, but I needed to find something here. I took some notes the other day related to your case, and I wanted to make sure that we had that as well. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me, what do you not understand?
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Aligretti, is find that you've unduly delayed these proceedings.
All I wanted to
Find you in direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor, I
contempt.
have a job.
Please take Mr. Aligretti into custody.
Don't
We'll
forget
try again
his
tomorrow,
script.
sir.
He needs his script to go with him. It'll keep him warm at night. I don't travel under these charges.
We'll be adjourned in F210947, and I'll open a new case on the contempt proceeding as required by rule.
Well, he didn't get tased, son of a bitch, and he didn't leave the court swearing and screaming at the judge. But he did spend the night in jail. Okay. All right, here we go. Here we go, guys.
Good morning, sir. What's your name? What's your name?
Joseph Jones.
Good morning, Mr. Jones.
Mr. Jones before.
Mr. Jones, I'm going to hear probable cause on your case. Probable cause is not a trial or a finding of guilt. It just gives the court more information about the allegations. Ms. Coronado?
Yes, sir. On April 5th of 2026, officer was dispatched to a robbery in progress call at 7700 Katy Freeway in Harris County, Texas. The call detail stated that a black male with green shirt and black pants was robbing the CW by strong arm aboard the Metro bus. Officers arrived and observed the defendant to be walking away. CW and other citizens thought that the defendant was detained. CW stated that she boarded the Metro bus and the defendant approached her and asked what was in the bag. CW told defendant not to worry about it. Defendant then put his arm to CW's chest and grabbed her arm while trying to grab her purse and her groceries. Defendant was able to retrieve a bottle of ranch dressing out of her grocery bag and began to drink it. A bottle of ranch dressing is valued at $5. He has out-of-county criminal history. For
No, you don't steal an American's ranch dressing and drink it right in front of them. You can't do that, sir. Sir.
The theft is the ranch dressing?
$5.
Yeah. Ms. Coronado, I think there's some, okay. I'm gonna find no probable cause, sir. That just means that the court doesn't believe there's sufficient information to move forward. That doesn't mean that the state won't take this case in and get it indicted. But for now, you will be discharged and we're gonna set this case out for 14 days. Okay, you can have a seat.
Okay. That was actually the 184th District courtroom. Okay. I understand how you're feeling right now. That guy walked up to a stranger, held them against the bus seat, stole their personal item, consumed it in front of them. Okay? So the judge dismissed the case because ranch dressing is $5 because they said robbery. Later on, a little bit later, the prosecutor was like, he assaulted her. And the judge said, yeah, maybe should have been filed as an assault. So they're going to refile that as an assault. He's not off the hook. All right. I don't know if this next one, I don't even know if I want to watch it with you. So, I'm so mad. It got me so mad.
It was 30-02-0712 FD-001970 out of Hancock Superior Court, Hancock County, sentencing date 9/11/2008. 3/20 of 2015, judgment of conviction as an A misdemeanor and lifetime suspension reduced to 200.
I don't know if y'all realize it. We hear the prosecutor on this one. Because he's mad. He is super mad. He should have a little cape on right now. He is super mad. Normally we don't hear this prosecutor. I have to tell you everything this prosecutor's saying. But the judge we hear crystal clearly.
Days. So that was in 2000.
Hancock County?
Yes.
That wasn't a DUI. I was driving on.
Okay, HTV. Okay, but so a judge cut you a break in 2008, correct? You had a lifetime suspension.
Yes.
And since 2008, you have basically repaid that trust, repaid the judge helping you out by getting more and more DUIs. Is that correct?
To be perfectly honest with you, I wasn't even aware that he did that.
I have no further info.
Mr. Bate, we redirect. All right, you may step down. Thank you.
Okay.
Any additional witnesses, Mr. Bate? Any witnesses from the state?
No, sir, this argument.
Argument from the state?
Well, apparently the defendant has driving skills that even police officers don't have. It's, I think it should scare the other kids out of you that he can drive 100, but 100, take him at his word. I mean, he even said he's very fast. That's pathetic. That's dangerous. That shows that he doesn't really have control of himself or whatnot. He was drinking while driving. What probably caused that? Yeah, the case.
In case you can't understand him, even though we can finally hear him. Back. He was driving 122 miles per hour, running from the police during his 6th DUI. 6th.
Truly in there. It was an open container. Oh, that was from last week. It was just cool. No. And then he tells the officer he was drinking. Whatever. Oh, but I lied to him. Why would you lie about it? That makes no sense. You would say you weren't drinking. He's all over the place. There was no effort for the public. There was no empathy for you, for me, for these people here or whatever. 6 DUI. It's all about him. Put me in jail. It'll hurt me. It'll hurt my job. It'll hurt my dogs. It'll hurt my mom. But nothing for us. Absolutely nothing for us. I mean, that's pathetic. I mean, at least you can say, look, I got behind the wheel of a car and I put people in danger and things like that, but not. I mean, literally, it's all about him and doesn't really care about any of us. That's very good. He says he has this under control. I don't think he has this under control, Judge. I think he's somebody who has maybe give him a year or two or whatever when he's has some therapy and things in it. Not right now. He drank after. He drank after this case happened. The person, and he basically, I just got lucky. Didn't hurt anybody. I mean, those are his words.
No.
How many more your words? I agree. How many more DUIs are we going to have to tolerate before somebody sends this guy a message that he's a very dangerous individual? Everything you heard from here basically is me. Doesn't seem like it's a big deal. Oh, well, I mean, his comment about the speeding, I was kind of taken aback by that because it was very casual. This is a misdemeanor, so technically you don't have to find aggravated mitigators, but I think it helps talk in those terms. He was a 0.23, so obviously he was not just drunk, but very drunk and that type of thing. He was drinking while driving. Okay, let's not kid ourselves. His comments about the speeding and things like that, I think that should be concerning this court. I don't think you should cut this guy in place. I think that basically everything he's told you, he has no empathy for anybody. It's his world, we just live in. I'd ask for a fully executed sentence in this particular case. This is now a 6th DUI. He says he's learned his lesson. No, so, I mean, this is somebody who, based upon what he's told you today, is dangerous. If he gets behind the wheel of a car, he's going to turn people. He's going to make him speed because he can control it at 100, but not 120, 130, whatever. He didn't deny that. I'll be honest with you, the fact that this is a 6 DUI with his
Sorry,
attitude,
CJ.
I'm genuinely shocked that this is not a fact case. He has hurt somebody or has killed somebody. If somebody doesn't stop it right now, that's what's going to happen. And I ask you that you do that. I ask that you put him in jail, because at least we know he's in jail. He's not going to be out on the street jeopardizing your lives, their lives, and everybody else's lives. Okay?
Mr. Bate,
Yes, thank you. Well, there are reasons for pre-sentence investigations. This case is perfect for a pre-sentence investigation. So it doesn't take
122 miles an hour with a BAC of .023. And he's still alive. Kelly, thank you so much. Thank you.
prosecutor or my bias, so we send it to a court employee. So I just go over what she's done, because she sits down for a month. We supply her information, and where she comes up with it after listening to everything, I will tell you. And I feel bad I interrupted him a lot. He is a different guy. And I'm not intelligent enough in the areas I need to be to understand him, but I don't know if he calls Rain Man or what it is. I don't think he can lie, but what I'm impressed with and what Nicole Alvis was impressed with is he tells you he hasn't drank since November. You look at what the psychiatrist says. You look at what the psychologist says. He's timely. He's there. He's doing the plan. This is a plan he said. It's not something that the court ordered. This isn't something I told him to do. Hey, you need to look good in front of a judge. Boom, this is stuff. He didn't even really want to give me this information. And then pulling everything out what he's lived. And then it doesn't give it as an excuse. And I know sometimes as he talks, he's just so literal, it sounds like he doesn't care. Well, actions speak louder than words, 1,000%. What's he done? He's gone to psychiatrist, he's gone to psychologist. He's gone and got all the treatment. You look at what his employer says, and I'm spot on with this. This is a phenomenal guy working. So we got to look at it. And, I live in this community. I mean, I got kids, I got grandkids, and, we got to reform him. Maybe just can't throw him away forever and hope, no, we don't. No.
Guys, you're really going to like the judge on this one, but not the sentence, but the judge.
I'm going to give him a right of allocution before you're done. I'll give him a chance. Yeah.
I don't
Thank
mean
you.
to be harsh with him, but
No, you need to be. I know.
But so we take it all out, every great thing I could say, anything from a lawyer's perspective you want a client to do. He walks in the door and he is taking this on. It's just the way he's built. Shows me pictures of his house. And maybe as an old guy here and knowing the love of animals I got, and I know we laugh about it, I do think these poor animals that he's rescued, long incarceration, lose his house. I'm concerned for his well-being. Here we go again, and I don't see how that helps. It doesn't mean he walks out of here and he's not on probation, and that we don't have him on home detention, and we don't know exactly what he's doing. And if he trips up, boom, you're gone. We gave you a shot. You didn't listen. You lied to us in court. Boom, you're gone. So we're asking that you take the recommendation of the
Sir, please shut up. Please, just shut up for a second. God. Terry, it's your birthday. Happy birthday. If you're saying happy birthday to Terry, it's Terry with an I. Like Bren typed. Happy birthday, Terry. I hope your sisters get you something good today. Hi, Bill. Oh my God. Guys, I get all nervous when Bill shows up because he's very, very famous. And famous people on my stream is just weird. Boom. I'm actually just using Bill right now as an excuse not to press play because I'm about to get pissed off. I'm about to get so mad. Alright. Here we go.
Hours, the probation department, where you sentence him accordingly. You make him on the home detention. You make him serve. And I know that we asked for weekends and, you know, whatever the court does there, you know, he's going to punish himself. Thank God he's turning around. And at this point, you know, we're here almost April, and since November, we're good. There's no guarantees, no guarantees in life for any of us, but we ask that you follow the recommendation of probation. And that certainly gives you, it doesn't tie your hands, it gives you the ability. He trips up in any way, he takes one beer, boom, he's gone. And I think that, you know, ultimately, even with prosecutors, it's ultimately he's back out on the road. I want him informed. I want him to have all his medicine. I want him before he gets back out. That's just doing that. Thank you, Doug.
Thank you. Well, Shane, I find you to be credible for your testimony today. I don't think you got allocution. This is your opportunity to tell me anything you want to tell me, Shane, not subject to cross-examination. If there's anything you wish to tell me.
To be honest, the recommendation, won't be too soon. I think that actually would be helpful for me. I don't see myself violating anything, but just having somebody, you know, looking over my shoulder every once in a while couldn't hurt. I don't see how it could. Sorry, I had something to say. I think what it was.
Okay. That's all right. All right. So when you're up here testifying, I find you to be credible. I do think that there are reasons, not excuses, but reasons for your behavior. And I empathize with you for the things you've had to go through. But I also note, Shane, that this is the sixth time, you know, and you were born during the blizzard of 78. And so you grew up talking about MAD, Mothers Against Drunk Driving, Don't Drink and Drive, you know, Click It or Ticket, all these campaigns that we have to stop people from drinking and driving. Like Mr. Bates said, there's a difference between having an alcohol problem and getting behind the wheel. I noted the time and date, August 23rd. I looked at the calendar. It was a Friday night. It was right there at the Fairland exit, not too far away. You passed it. It was Triton Central. They had a football game that night, home football game, opening one against Batesville. At night,
He was driving 122 miles an hour drunk past a kid's football game.
9 o'clock, I tell you, there's kids out on that road. There's kids that I coach. That's my community, my family. That fire department, you pass London Road. I'm on that fire department. Driving 100 miles an hour in the condition you were, it is by God's grace alone that you haven't hurt yourself or somebody else. So those are things that fire me up, Shane, to be honest, you know, that make me it. Go ahead.
Well,
I'll let you say something.
Just remembered what.
Very good. That's okay.
I'm sorry.
Tell me.
If you look at my driving record, I don't have any speeding tickets or any other violations besides this. I'm actually a competent driver.
Unless you've been drinking.
Yeah.
That's even more scary. I mean, I know what you're saying, Shane, but
Yeah.
that's even more scary. You know, so those are things that enter into my decision making. It's the sixth time, and the fact that you didn't burn the house down is just amazing to me. That you're lucky you didn't, you know, have that pan fire catch up and burn everything down. So you were very fortunate. Somebody is looking out for you. So I've got to try and.
He just said that the judge shouldn't worry about what speed he was going because he's an excellent driver at 122 miles an hour.
Figure out what's the best sentence, recognizing the prior history and what I think is appropriate. Mr. Bates, right. Even if I just lock you up for all 9 years, you're still going to get out. And as a society, we're better off. That's one thing I always try to figure out when you walk out the doors of that jail. What are the chances you reoffend? I don't want that. I don't think you want that. No, the society definitely doesn't want that. So I'm going to send you to 4 years. The first year is executed. The first 20 days of that is executed at the Shelby County Criminal Justice Center. The remainder is going to be on work release in Johnson County. So I've communicated with Johnson County while we're doing this. They have a bed space available. We have an agreement with Johnson County Work Release that I can send people over there. You're going to be able to do work release there. The next 2 years will be on home detention as a condition of probation, and the last year will be on probation alone. So I'm executing 1 year of the OVWI and 3 years of the HVSO count. You're going to do the 9 days straight. I'm going to give you a report date. You're going to report to Shelby County Criminal Justice Center on Friday, the 17th at 6 p.m., clean, sober, with a copy of your sentence in order.
Indiana.
After you complete those 9 days, between now and then, you're going to get with Johnson County Community Corrections so you can figure out your work release. You'll start your work release immediately when you're done with that sentence. If you are such a good employee, I'm pretty confident Barth Electric, that's who you work for, right, will work with you. I'm trying to do all things for all people here. I'm trying to save your
100,
job.
Monica.
It's not going to be easy.
Thank you for the cheers.
You got to figure something out with your dog. I hate that because I'm a dog lover myself. But, you know, at the end of the day, I'm not going to sacrifice the best interest of society for a dog. So what you do with your house is up to you. You could rent it. You could sell it, whatever. Just
1 year.
Bank it down and, you know, pay your mortgage and be done with it. Between now and then, that's between you and yourself and what you figure out. But I think this sentence gives you an opportunity to try and keep your job, to keep things as best as possible. At the same, you're holding you accountable, which is what I intend to do, is hold you accountable. Because driving on our roads at 3 times the legal limit, 100 miles an hour, is a grave danger to everybody out there. And I thank God that you didn't hurt somebody and didn't hurt somebody else. And doggone it, it's your fifth or sixth DUI, fifth DUI, right? Fifth DUI. So I said 6. Is it 6, Ed? All right, 6 DUI. And, you know, I think if I executed a good portion of this, I think the Court of Appeals would uphold that sentence. So I'm not too worried about that. But that is my sentence. License is suspended for a year, going back to the day it was first suspended. So
I don't have anybody. I don't have anybody to drive me around or anything. If I'm not
$42 an hour, I bet you can afford an Uber.
I don't have anybody to drive me around, Judge. This isn't fair. Oof, oof, oof.
Cart you around. So those are choices you got to make. I'm giving you an opportunity. What you do with that opportunity, whether you work at Greek's Pizzeria in Franklin or you continue to work as an electrician, that's entirely up to you. I don't really care. But that's your choice, what you choose to do with it. I'm giving you an opportunity. If
I put those emojis in to express how pissed off I was when I watched this. Oh, I was so mad.
You know, so you decide how bad you want it. You decide. So I think if I'm making $42 an hour, I'd pay a guy $20 an hour to cart my carcass around if that's what I needed to do. So I'd pay him $42 an hour for 2 hours at least work. You know, if I'm trying to keep my job and keep my house, you'll figure it out. I'm confident. You're an intelligent man. So
we don't do all the work, Johnson.
you don't have to do it in Johnson County. So I'm confident you'll figure it out.
Can I do work release in Marion County?
Nope. It's in Johnson County. That's who our relationship's with. Talk to Johnson County. They may allow you to go out of county. I think you just have to commit back and forth at the times, apportioned times. I don't think they care that you go to Lebanon or wherever you go. You just,
If he says he's sorry, which he didn't, by the way. He said that he was a competent driver.
gotta come back. But I don't know. I don't know exactly what the rules are, but you got to abide by them. So it's either that or you just do your time in custody. So I figured this is better. No, 6 p.m. 6 p.m. All right, that will conclude your hearing. I'm going to take a break. Oh, no, I do. Thank you. I need to go conditions of probation. These are your standard terms, conditions of probation. First of all, as far as home detention, you'll be confined at your home at all times unless you're working, looking for work, going to school, going to church, going to the doctor, those kinds of things. You will prepare a schedule in advance. You will abide by the schedule.
He rescued some dogs. So that was one of the mitigating factors in his case, that he's such a good guy because he rescues some dogs. That's the whole dog thing. The dog wasn't in the car. Dog didn't get hurt. All right. All right. Here we go, guys. Here we go. Guys, buckle up for this one. Just saying.
Darlington. I'm not listening to anything else you have to say. Your testimony is finished. Susanna Brown, could you state your name for the record, please?
Susanna Marie Brown.
The record should reflect the defendant appears here in person and with counsel John Dreyer. The state appears by Chief Deputy Prosecutor Andrew Salter. The matter set today for hearing on the recommendation of plea agreement. Is that your understanding of why we're here today?
That's correct.
Before the court can accept a guilty plea from you, the court must be
Oh no, I see how dogs treat you, Bill. You better not go near those dogs. They'll bite you.
satisfied that you understand the nature of the charges against you, the possible penalties, and your constitutional rights. That your plea of guilty is freely and voluntarily made. There's a factual basis for the plea, and that you are in fact guilty. It will therefore be necessary that we ask you some questions and take some evidence from you. If at any time you don't understand something that's being said, please interrupt the proceedings so we can clarify matters for you. You understand? You can also speak to your attorney at any time. Do you understand? How old are you, ma'am?
Lipstick.
I'm 35.
How far did you go in school?
1/3.
Did you graduate from high school?
Yes, ma'am.
Do you read, write, and understand English?
Yes, ma'am.
Do you suffer from any mental illness?
Bipolar, PTSD, anxiety, and depression.
And when we were last here and started this sentencing hearing, you advised that those were your diagnoses and that you were seeing a doctor at Valley Professionals. Are you still engaged with them?
Yes.
Yes?
Yes, ma'am.
And you're taking some medications still?
Yes, ma'am.
Is there anything about your diagnoses or your medications or your lack of medications perhaps, which might impact your ability to understand these proceedings today?
No, Your Honor.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No, Your Honor.
As I understand the terms of the plea agreement, you would be pleading guilty to count 1, operating while intoxicated, causing endangerment as a Class A misdemeanor, and count 2, neglect of a dependent as a level 6 felony. The agreement on sentencing is that sentence in excess of time served shall be suspended on terms set by the court. It looks like you were in jail for a few hours, right?
I was in there for a day and a half.
We show that you were in there for 7 hours.
No. I got in there at like 2 and then I stayed another night and then I got out when I saw you.
Okay, well, we'll just look it up here to be sure.
2 in the morning. Is that okay?
I got booked
We
in at
realized,
2,
Bobby.
yeah, so I didn't get to see anybody that day and then I seen Judge Whittle on video court.
Wait till you hear what she did, guys.
The jail's records indicate that you were booked in on June 25th at 4:14 a.m. and you were released on June 26th at 11:49 a.m. Oh, so that's like
It's about a day and a half.
5 hours. That's 29 hours. Okay.
I promise it wasn't 7.
No, you are correct. Our math was way off. It's a good thing we asked, right? That's what we asked.
But we figured out the math was off earlier. Not yours.
Oh, ours is now, but the probation officers might be.
So sometimes in jail, they got that one case. Remember, I had to email you. They were off. That's the only time I've seen.
Yeah, I think because they took someone to the hospital or something. I think that was your case. All right. In any event, the plea is that you would receive a sentence, any sentence in excess of time served shall be suspended on terms set by the court with the state to make no recommendation. The defendant shall be pre-screened for home detention by West Central Regional Community Corrections prior to sentencing. The court shall convert judgment of conviction on count 2 to a Class A misdemeanor upon the defendant's request, if she so requests upon successful completion of probation, pursuant to Indiana Code 3538(1)(1.5. All other terms of sentence left to the sole discretion of the court. Is that your understanding of the terms of your plea?
That's correct.
And Mr. Dreyer?
Yes, Your Honor.
And state.
Yes, Your Honor.
In order to convict you of count 1, the state would have to prove beyond a reasonable doubt at trial that on or about June 25th, 2025 in Montgomery County, state of Indiana, one Susanna Marie Brown did operate a vehicle while intoxicated in such a manner that a person was endangered. And in order to convict you of count 2, the state would have to prove beyond a reasonable doubt that on or
I should have said this earlier. Bobby, sugar. Guys, if YouTube is messing up, Go to Twitch. You can watch it on Twitch.
About June 25th, 2025 in Montgomery County, state of Indiana. One Susanna Marie Brown, having the care of a dependent, specifically her daughter CWH3, whether assumed voluntarily or because of a legal obligation, did knowingly place said dependent in a situation that endangered the dependent's life or health, specifically left said child without supervision during the night. You understand the state would have to prove those elements beyond a reasonable doubt to convict you of count 2.
That's right.
Okay, so far we know that she was out drinking and driving. She left her 3-year-old at home alone to go out drinking and driving, right? There's a reason for it. Here we go.
Count 1 is a Class A misdemeanor. It's punishable by a sentence of up to 1 year in the Montgomery County Jail, a fine of up to $5,000. Count 2 is a level 6 felony, punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2 1/2 years, with an advisory sentence of 1 year. It also carries with it a maximum fine of $10,000. Count 1 is classified as a major misdemeanor traffic violation. A conviction for count 1 would be reported to the Bureau of Motor Vehicles and become part of a permanent driving record for you. If you accumulate 3 major misdemeanor traffic violations, convictions on your driving record in any 10-year window of time, the Bureau of Motor Vehicles on its own would determine that you're an habitual traffic violator. Your driving privileges would be suspended for a period of 10 years. Your driving privileges in this case could be suspended for up to 1 year. If you are convicted of count 1, if you're charged again with another OWI in the next 7 years, the state would file that new offense as a level 6 felony, regardless of the other facts and circumstances. Do you understand those possible penalties?
Yes, Your Honor.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court's subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination, and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. Do you understand those rights, ma'am?
Yes, Your Honor.
Do you understand that by offering to plead guilty today, you're waiving those rights or giving them up?
Yes.
You understand that there will not be a trial. The state is not bringing witnesses in here to prove that you're guilty, but that you'll be proving your own guilt by your own sworn testimony.
Yes, Your Honor.
You also have the right, ma'am, to be represented by an attorney. If you could not afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand that you have the right to counsel?
Yes, Your Honor.
That's a right that you never waive. You don't give that up, even by pleading guilty. And even if you go forward today with your guilty plea, Mr. Dreyer would continue to represent you to the conclusion of these proceedings. Do you understand?
Yes, Your Honor.
Do you understand that the plea agreement is an agreement between you, your attorney, and the state, and that the court is not a party to it?
Yes, Your Honor.
If the court accepts a plea, then the court becomes bound by its terms, just as you are. Should the court reject the plea for any reason, your not guilty plea would be reinstated for you, and today's proceedings would not be a matter of record. Do you understand?
Yes, Your Honor.
Do you understand that in order to determine an appropriate sentence, the court must consider what are called aggravating and mitigating factors? Aggravating factors are factors which weigh against you, which might make your sentence more harsh or punish you more severely. For example, if you have a prior criminal record, the court would consider that an aggravating factor. Mitigating factors are factors which weigh in your favor, which might make your sentence more lenient. For example, the factor offering to plead guilty might be considered a mitigating factor. Do you understand the difference?
Yes, Your Honor.
And do you understand that the court is required to consider both aggravators and mitigators to determine an appropriate sentence?
Yes, Your Honor.
Do you understand if the court accepts a plea today and enters a judgment of conviction against you, if you're ever convicted of crimes in the future, this conviction would serve as an aggravator for future sentencing purposes?
Yes, Your Honor.
In other words, your criminal record follows you. You understand that?
Yes.
Has anyone forced you to plead guilty?
No, ma'am.
Has anyone made any threats against you or anyone else to get you to plead guilty? Has anyone placed you or anyone else in fear in order to get you to plead guilty? Has anyone made any promises to you outside the terms of your plea agreement to get you to plead guilty?
No,
Is your plea of guilty today your own free and voluntary act?
that's correct.
Are you satisfied with the services Mr. Jair has given to you as your attorney? Do you believe that he's properly representing you?
I do.
And is it still your intention to go forward today with your guilty plea?
That's correct.
Mr. Jair?
Ms. Brown requests the court withdraw her earlier plea of not guilty and enter a judgment consistent with the terms we've submitted to the court.
Ms. Brown, you've heard your attorney's motion. Do you join in that motion, ma'am?
I joined to that motion, Your Honor.
The motion will be granted. How do you plead then to count 1, operating while intoxicated, causing endangerment as a Class A misdemeanor? Pursuant to the terms of your plea, do you plead guilty or not guilty?
Guilty.
And as to count 2, neglect of a dependent, a level 6 felony, do you plead guilty or not guilty?
Guilty.
You'll step up to the witness stand and raise your right hand to be sworn. We'll take some evidence from you.
Suzanne.
Here's some tissue.
Take that back with me when I go back.
You stand, please, and raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. Please state your name for the record.
Susanna Marie Brown.
Thank you. State.
Ms. Brown, is your middle name Marie?
That's correct.
And were you born May 14th, 1990?
That's correct.
On June 25th, 2025 in Montgomery County, Indiana, did you operate a vehicle while intoxicated in such a manner that a person was endangered, in this case, yourself as driver potentially?
That's correct.
And on that same date, also in Montgomery County, Indiana, did you, having the care of a dependent, specifically your daughter CWH 3, knowingly place that dependent in a situation that endangered the dependent's life or health? Specifically, did you leave the child without supervision within the night?
That's correct.
Was this brought to the attention of authorities because of the crash?
That's correct.
And you actually suffered some injuries in the crash, is that right?
Yes, sir.
And you spoke with the officer and told him that you'd had some drinks earlier?
That's correct.
All right. I don't have any other questions on fact, Sharon.
No question.
Was there only alcohol in your system that night?
That's correct.
Your child was how old? 3 years of age?
Yes, Your Honor.
Male or female?
Family.
Why would you leave her alone so you could be out running around?
What happened was I got into it over text message with somebody and they called my daughter ugly and made fat and was saying, let's meet up. And she was sleeping. So I was like, I'm tired and I made a bad judgment call. And I was like, okay, I'll meet up with you. And I was going to go fight them by myself.
Somebody sent her a text message and said her daughter was ugly or stupid. I don't remember what she said. She's like, all right, bet, I'm going to come beat your ass. And she got in the car. And she went to go fight them and crashed her car.
There's no reason to lie.
No, I'm glad that you're not lying, but in retrospect, surely you understand that that's just a horrible idea. Like if you had been severely injured or, God forbid, killed, she would just wake up not knowing where you were and no one would be there.
Yeah.
Right? So did the Department of Child Services get involved with your family?
That's right.
What's the status of that?
I completed it.
And their daughter's back in your care?
They never left my
She fought them when they showed up too.
care.
Okay.
They stayed with my dad for like 2 nights while I was in jail.
Do you know what your BAC was, your alcohol content?
I'm stating, I don't know.
It was on the lab test, it was 0.122.
Did it indicate whether there was anything else in her system?
Well, if the result comes back over 0.10, unless we request an additional test, they don't do the drug test, so.
All right, any other questions for this witness from your side?
Okay.
No questions.
All right. Cool. Ms. Brown, have you reviewed the pre-sentence investigation report, the records check?
Which pages? I have reviewed that,
This
right?
thing here.
Yes.
Yes, is it correct?
Yes.
All right, so your only prior conviction is this 2014 case where you were convicted of possession of controlled substance, possession of paraphernalia, possession of marijuana.
That's correct.
You were placed on probation. It looks like you had a violation. They placed you on drug court. You violated drug court. They placed you back in, and then you successfully completed the drug court program.
That's correct.
In 2015.
Yes, Your Honor.
Okay, so why are you going back to using substances?
I was drinking and that was it, and
I was drinking and that was it. She's like, yeah, it wasn't heroin, Judge. It was alcohol.
somebody said the right thing, I guess, that night. I didn't know I was bipolar. I didn't know, and I'm not blaming it on that, but I don't know. I just snapped. Okay.
So would you agree that but for you using alcohol that night, you wouldn't have responded that way?
I mean, yeah, I probably wouldn't have responded that way. I might have got angry, but
You can go to bed and tomorrow's a different day, right? You can deal with it tomorrow when cooler heads prevail.
yeah.
All right. Well, we'll find that Susanna Marie Brown is a female person presently 35 years of age, having a date of birth of May 14, 1990, that she understands the nature of the charges against her, the possible penalties, and her constitutional rights. That her plea of guilty is freely and voluntarily made. There's a factual basis for the plea that she is in fact guilty of count 1, operating a vehicle while intoxicated, causing endangerment as a Class A misdemeanor, and count 2, neglect of a dependent as a level.
I've never seen them actually dismiss a case after a plea, after she pled guilty, Donald. That would be a first for me.
Felony. The court accepts the plea agreement and enters judgment of conviction accordingly. Mr. Dryer?
We also filed for specialized driver.
She was granted specialized driving privileges previously, but she never submitted her proof of insurance, so they never went into effect.
Yeah, I didn't have a car.
Yes, Bill.
Now I was able to get a car with my tax return money.
Do you have questions for your client, sir?
Yes, sir. You've accepted the plea, correct? You know, sometimes we got all these different stages of these things. I just want to make sure. There's some sentencing stuff she'd like to know, that she'd like you to know, please, the court.
Sure.
Suzanne, you had something you wanted to read to the judge?
First and foremost, I want to thank the courts for allowing me to speak today. If you look at the files in front of you, it looks messy, and to be quite honest, my life has been messy for as long as I can remember. Perhaps that is due to the bipolar I was just recently diagnosed with, or maybe it was from the lack of having an active mother around when I was younger that led to me finding acceptance from friends offering a quick fix to feelings. Whatever it boils down to, at the end of it all, I'm just a woman, a mom, a daughter with a handful of mental illnesses that seems to continue to develop as my age continues to increase. I am imperfect in many ways, but I wake up every day trying to be better, trying to understand my mental health, trying to work through and understand PTSD and bipolar. And since the accident of why I am before you today, I have learned a lot. I've started medications for diagnoses I didn't even know I had. I have started therapy and I completed IoT. I've worked hard alongside DCS and Family Pres and completed all the requirements. I should have never been on the road on June 25th. I realized I could have killed myself or someone else. I realized not every action deserves a reaction. And even when I feel the mama bear in me just trying to protect my girls, sometimes I need to take time to process and then assess the situation. In this process of trying to stand up and protect my girls, every day, it took one person's dumb comment for me to almost lose my girls. I'm not perfect. I have no idea why I tick the way I do, but I'm trying my hardest to be the mom my girls deserve, the mom I didn't have, the mom my girls can be proud of. A few weeks after this accident, I hit 10 years clean from heroin. It was then in a rehab holding my little girl that I wondered if I could actually be a mom, if I could actually succeed, scared to death to leave, wondering what would have happened if I failed. June 25th, I failed my girls. I ruined our yearly trip to Florida. I totaled our car. I sat on a mat in a cell alone, realizing I had failed my girls, the one thing I was most afraid of doing. My one decision affected so much, but sometimes the harder God shakes our world, the bigger the lesson we learn. I am far from perfect, but I want to thank this court for their resources and to help me with my mental illnesses. And I want to sincerely apologize for the way my actions have affected my community, my family, and my growth. I know my fate sits in your hands today, Your Honor, and I pray you find just a little mercy in your heart for a mom who's just trying my best to get this thing called motherhood and life right. No matter how many times I stumble, I will not fail because my God is greater than addiction, greater than mental illness, and greater than my end.
Suzanne, the judge had asked you about Child Protective Services getting involved in your case after this accident. And they didn't take your kids, but you had to go through what's called an informal adjustment plan. Is that right?
That's correct.
And looks like that went from July until late January of this year when you were discharged, right?
That's
And
correct.
you were discharged because you did what they told you to. And is that how you got diagnosed, that you had bipolar disorder?
That's correct.
And you
Where
didn't
was
know
that? I'm
that?
sorry to interrupt. Where was that?
DCS sent me to Indianapolis to get diagnosed, and then I was going through Cummins, but they didn't have a med appointment, so I switched over to Valley Professionals.
Do you know where you were diagnosed in Indianapolis?
It probably says it in the DCS report, but I do not know the exact name of it.
That's okay. Mr. Dyer, you may continue. I apologize for that.
Thanks, sir. And does that perhaps part with the bipolar disorder? Do you understand what the disease is about?
I know that I'm learning that there are stages of depression that I have and mania that I have. I know that if I'm being treated only for depression, it won't work or help because it doesn't help with the mania. So I'm on a mood stabilizer that will help.
Keep you from overreacting. Is overreacting something you understand that can be a symptom of, or
Maybe you should just testify, lawyer. Maybe you don't need her.
caused by the bipolar disorder?
Correct.
And you think that really contributed to a bad decision that night?
I do. I don't know what. It's just I finally took too much on and snapped. That's only I.
Who's that in the drinking though too? It's a bad combo,
Correct.
right? Yeah, approach please.
You may.
Suzanne, we You applied to West Central Regional Community Corrections, correct, for house arrest?
Yes, I did.
And they approved you, right?
Correct.
And I'm going to show you what I'm going to mark. Sorry.
Yeah, but
Let's show you what I've marked as exhibit
she was just being mama bear. She was just being a mama bear.
E. Is that the letter from West Central saying you're good to go with them?
That's correct.
Okay. Yeah, I submit the exhibit. No different.
Show exhibit E is admitted without objection.
And I'm going to show you what's been marked with exhibit F. What is this? Some sort of, oh, sorry, I ready to show this. Okay. Can you tell us what this is?
My graduation certificate through comments from my IMC group.
Okay, is that something CPS got you involved in?
I believe it was part of my pre-trial or my
Pre-trial services.
yeah.
Okay. Offer exhibit F. No objection.
Show exhibit F is admitted without objection. Is this your only copy? Yes? Do you want a copy of it? And we're gonna keep this for.
Oh, he printed me a letter for it.
Okay.
And then Susanna, is this okay, Judge? Just letters and that. Is that okay?
Are they A, B, C, D, and E? Or A, B, C, D, E?
I'm sparing you guys.
I'll mark it as you.
Oh, okay. Susanna, tell me what's exhibit E here, please.
No, that's not. He's already.
Oh, that's A.
A.
What did I say?
Yeah. Exhibit A?
Yes.
And that is the girls and I at the Sunflower Festival.
What are your girls' names?
Emma Wadley.
That's the little one?
Emma is the oldest one, she'll be 10. And then Penelope, she's gonna turn,
She's the brown hair
yeah,
girl? Okay.
and Charlie, she is 4.
Charlie, Charlene?
Charlie.
Charlie, okay. Offer exhibit A, please. No objection.
Show exhibit A is admitted without objection.
Showing you will be marked exhibit B. Is that you and Charlotte?
That is me and Penelope at the Pumpkin Festival.
She's got brown hair. I thought,
No,
oh, you had blonde.
no.
Forget about that.
Brown hair, brown eyes.
Okay. And exhibit C, that's you and your girls again?
That's just the girls getting ready to go to a dinner.
Okay. Offer exhibit C, please. No objection.
Show, any objection to B?
No objection.
Show B and C are also admitted without objection.
Last but not least, what's exhibit D?
And this is my 2 oldest girls winning their pageant. Again.
Pretty girls.
Any objection to D?
No objection.
Show exhibit D is admitted without objection.
Thanks, sir. You receive child support for those children?
I do not.
So you raise them on your own?
I do.
And are you employed?
As of right now, I'm not.
Before this happened, you were employed, right? What'd you do? Home health care or something?
Daycare.
Home daycare. And all your people left you, didn't they? After this. So how are you making ends meet?
Right now, I'm getting help with family and stuff. Doing odd and end jobs with my dad around his church, or gonna be helping him mow and stuff.
So would it be fair to say you have a tough time financially,
Yeah.
especially since you don't get support for those pretty girls? And do any of the girls have any special needs?
Charlie was diagnosed earlier, like a year ago with autism, level 2 and sensory disorder.
And does that require special care?
She would need to start ABA therapy, which I'm looking at in Wayne, but it's hard for me to get her to a therapy because it would have to be 20 to 40 hours a week. That's what they're suggesting.
How would that be paid?
We have Medicaid and we applied for the Medicaid waiver.
You live on your own with the girls?
Right.
How do you pay rent?
I'm an income-based home, so I don't have any rent right now.
You said you got a car with your tax refund?
That's correct.
So you're asking the court to give you specialized driving privileges if court determines there's going to be any further suspension of your license, right? You need that to be able to get these kids around, right?
Yes.
I've told you that you're going to have drug and alcohol evaluation. You're probably going to have to go through for probation, right?
Yes.
And
I already did that through Cummins,
okay.
but
Well, it'll be up to your probation officer if
Yeah.
you accept that. And we've talked about how important it is to follow the terms of probation, right?
yes,
You're going to give that a top priority in your life, right?
absolutely.
And you understand that the state has given you quite a benefit here in saying that if you successfully complete probation, you can ask the court to convert that eviction from a felony to a misdemeanor.
Yes,
Right.
and I'm thankful for that.
Yeah. In your request for specialized privileges, you said you need to take your daughters to doctor's appointments and yourself to therapy.
Mr. Drag, she's been suspended 232 days. I'm not planning to have a longer suspension.
Okay.
This is her first of the rule.
All right, thanks, Sharon. I don't have any other questions. Is there anything else you'd like to tell the court? By the way, your statement was very nice and well written,
Thank
and I didn't help you.
Thank you.
State questions for this witness?
No question, Jamie.
Are you attending AA or NA meetings?
I don't have a way to get there. Honestly, I have discussed with Lindsay about, how I would like to do them. If I do, over the phone or something, not inconvenient, like.
Yeah, you can log on to AA or NA all over the world at any given time. There's a meeting almost all the time, anywhere.
We could go to AA right now.
Okay, probation can assist you. All right, anything further, Mr. Dry?
No, thanks, Your Honor.
Anything further, state?
No, Your Honor.
And
Has
y'all
DCS
should.
closed their case? Okay. All right, you may,
I didn't offer that as a, Your Honor. I've got it if you'd like to see it.
it's okay, I'm taking your word for it. You others should pick anything.
This is like January 20th, Judge Chad granted the order discharging her
For the informal adjustment.
informally.
You may sit down. Further evidence, Mr. Dyer?
No, thank you.
Evidence, state?
No, Your Honor.
Ready, Mr.
Your Honor, Suzanne has been through a lot. She didn't know that she had this problem with bipolar disorder at the time this happened. Of course, she's not blaming everything on this. You know how these things work, especially when you add alcohol to the equation. But she had undiagnosed mental health problem that, ironically, this incident helped her uncover. She, because had this not happened, who knows what would have happened. So now she's getting medication for it. I think that's a mitigating factor. She's remorseful. She's got 3 young kids. They've all suffered. She's lost her livelihood. It's been very, very tough. She's not getting support for those poor girls. And other than that, I'm talking to you, I'm a guy with no kids. But someone takes a dig at your kids, I can't imagine responding to that. And I'm not saying what you did is right. You know what you did was wrong. But given the fact she had that mental problem with the bipolar disorder that at that time was not diagnosed. She had been drinking. I think a lot of people would say, I can understand where you're coming from. Notwithstanding the fact, yeah, it was a mistake, but I can understand. So now she's working with it to learn how to deal with the left and right limits of what the Lord has.
Let me tell you what she did. She's sitting at home drinking. She's drunk. Somebody sends her a text message and says, your kid is ugly or stupid. One of those two. 3-year-old. So she leaves her 3-year-old alone at home, gets in her car to go fight this person, and crashes her car in DUI. That's what she did.
Out to her. And she cooperated with police. And, as far as the underlying accident's concerned, that crash, man, she lost that car. So, my heart bleeds for Suzanne. I feel terrible for her. And I know she feels very terrible. She's been up there struggling to keep those tears back. I have every confidence that going forward, she's going to be fully compliant with probation, and she's going to work on herself and her sobriety to never have this happen again, and keep herself going to her therapy sessions with her treatment. I don't think we're going to see her in this court ever again.
Thank you.
That's all I have.
He's done. Now it's the
Yeah,
judge's
no,
turn.
argument, John.
Brown, let me just tell you that I am a parent, and I can't imagine getting in a car and driving out to meet someone to engage in a fight because someone called my son stupid at 1:00 in the morning. I understand the mama bear mentality, but that's ridiculous. That's ridiculous. That's the actions of a 14-year-old, not someone who's 35 years old. So, bipolar or not, that should just never happen. And you are raising 3 little girls. So they are learning how to act based upon what they see you do. And so when you engage in that kind of behavior, you're telling them that that's the kind of behavior that's appropriate. And it's just not. Not in this day and age, not in this society, not ever. It's just not okay. And like I said, I understand wanting to protect your kids, but there was no harm to your children that night. It's that somebody hurt your pride, and so you were bound to do something about it because you were under the influence. That's it. So you can classify it as mama bear mentality, but that's not mama bear mentality. So hopefully those issues have been addressed with the therapy that you've engaged in and through the DCS case and through your pretrial services program. You've been involved for quite some time, and the report to the court was that you satisfactorily did everything that they required of you. So hopefully that'll continue with your probation, and you can address these issues so that you can make better decisions, because you have, again, 3 little girls who are learning how a lady is supposed to act by watching you. They're not watching anyone else. You can tell them how to act, but your words don't speak nearly as loud as your actions. So you need to keep that in mind, because little eyes and ears are soaking in everything that you're sending their way, even when you think they're not. Court finds that the sentence that has been bargained for is appropriate. The court, having accepted the plea agreement previously, has taken into account the contents of the pre-sentence investigation report, as well as the reports from pretrial services regarding your engagement in their services while this matter is pending. I am sympathetic to the fact that you are unemployed and have these 3 children that you're trying to raise without child support. But if they're engaged in pageantry of any sort, which it looks like from one of your exhibits, somewhere the money is getting paid for somehow. And so you're going
free in Darlington.
I'm not listening to anything else you have to say.
It wasn't free. Look. Pageants are freaking expensive. The dresses, oh my gosh. The makeup, the photos, you have to get headshots. They are so expensive. It wasn't free. It wasn't free.
Your testimony is finished. Somehow you have got to get a job so that you can support yourself and these little girls. It is not your family's job to support them. It is not anybody else's responsibility to support them. It is yours. And I expect that you will get a job and that you will keep a job while you are on probation. It will be a requirement of your probation.
And they are stupid too.
And until you are employed full-time or at least 20 hours per week, you're going to be donating your time as community.
Dressing these little tiny little girls up as adult women and makeup, and it's stupid.
Service. So you need to get a job. It's time. Court finds that your plea agreement is entitled to the court's consideration because you pled guilty to both charges pending against you.
Makes me want to drink alcohol, get in a car, and beat their mom's ass.
Court finds that the neglect of a dependent charge in and of itself is not an aggravator, but the circumstances surrounding the charge are an aggravator for the court's consideration. It's just not appropriate to leave a 3-year-old at home when you're under the influence and you go out to fight somebody because someone said your child is dumb or whatever it was that they said. It was so insignificant that I've already forgotten. So you should have forgotten it and gone to bed that night and dealt with the issue the next day when cooler heads prevail and sober minds can direct your actions.
Do we really
Or finds the
think
beast.
it was the alcohol that made her do this? Come on, Judge. Next morning would have been the same thing.
Sentence that is appropriate in this case is 1 1/2 years. That'll be suspended. You'll be placed on probation for 1 1/2 years on the following terms and conditions. You shall not violate the law. You shall notify probation of any arrest within 72 hours. You shall report to and cooperate with your probation officer as directed. You shall continue to report to probation until you are relieved from doing so by the court, even if a modification or revocation is pending, it being at all times your responsibility to maintain contact with probation. You shall provide your address and telephone number to probation. You shall not change your residence or your telephone number without notifying probation in advance. You shall maintain employment, notify probation prior to any change in employment. If you are unemployed, you shall actively seek employment. For any week that you're not employed at least 20 hours per week, you shall donate 20 hours of community service. That's really to keep you busy with something constructive. It also will help you hopefully develop a resume if you need some help in getting a job. Maybe that will be a stepping stone for you to do that. It's also going to improve your self-worth, and it's going to pay back the community for the engagement in our criminal justice system. It's all of those things, but really it's also to entice you to just get a job, because until you're employed, you're going to be donating your time. So it should entice you to get a job sooner rather than later. You shall obtain a written travel permit from probation before leaving the state, and you shall sign a waiver of extradition. You shall allow probation access to your residence at all times. You shall sign a Fourth Amendment waiver to allow for the search of your person or your property. You are specifically advised that probation, law enforcement, or community corrections may search your person or your property at any time without reasonable suspicion or probable cause. So if they want to search you, they can do so. You understand? You shall not consume or possess any controlled substance without a current valid prescription, nor any synthetic cannabinoids, which is spice, CBD oil, hemp product, or any other designer drugs. You shall submit to and pay for alcohol and drug tests of any kind whenever requested by probation, law enforcement, or community corrections. By signing your terms, you are specifically waiving any objection to the admissibility of those test results at a revocation hearing. You shall pay probation user fees. The initial fee is $100. The administrative fee is $100. The monthly fee is $30. The court will not fine you, but you have court costs of $189.50, an alcohol countermeasures fee of $200. You shall set up a written budget for the payment of all fees, fines, court costs, and program costs, all of which must be paid prior to being discharged from probation. You shall pay them at a rate of not less than $65 per month. You shall not drink or possess any alcoholic beverages. You shall not enter a liquor store or a bar. Sorry. You shall not possess any firearms, ammunition, or dangerous weapons. Thank you. You shall sign the vicious and aggressive animal policy and abide by its terms. You shall submit your DNA to law enforcement within 7 days. You shall follow all directives of the Montgomery County Probation Department. You shall complete a substance abuse evaluation. You shall successfully complete all education and treatment recommendations made by probation, pay all the costs when they become due, and authorize the release of information to probation and the court. You shall complete mental health counseling as probation directs and authorize the release of information to probation and the court. You shall perform 50 hours of community service at a rate of not less than 5 hours per month. That's regardless of your employment status. You shall not operate a motor vehicle for a period of 232 days, commencing on August 21st of 2025. That time has elapsed. You shall successfully complete any program as probation may direct. You shall attend at least 3 self-help meetings per week, obtain a sponsor, and verify your attendance. A lot of things will qualify for that. So obviously AA and NA. And again, you can log on and find a meeting almost anywhere at any time of day. I mean, around the world, but a lot of them are conducted in English. AA, NA, obviously celebrate redemption, celebrate recovery, attending church, meeting with a mentor, meeting with a sponsor. A lot of things will qualify. So talk to probation about what they will accept. Do you have any questions about your terms? Probation is going to be closed by the time you're finished here, so you need to report to them by 9 a.m. tomorrow morning. All right. Do you have any questions?
Yeah, question.
You?
Do you have any questions?
All right. Mr. Dry is going to have you sign a copy of your terms.
Staying on top of that, the sessions and all that kind of stuff, we met as the probation officer, because if you go a month without hearing the two,
Year.
that may take you and sit.
Yeah, you're going to have it.
Nice. That's the thing for 6 months. Oh, he's gonna give it to him. Okay.
All right, let's go to an eviction next. Not really.
Testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
All right, Mr. Brown?
Ms. Perez, can you please state and spell your name for the record?
Antonia Perez, Antonia, last name Perez.
And what is your relationship with Vilgar Property Management?
I am the property manager for Vilgar.
And does Vilgar lease a property at Michigan City, Indiana?
Yes. Yes.
And is the tenant in that property Jessica Alvarez, who's the defendant in this case?
Yes.
And at the last hearing, Ms. Alvarez, which was March 12th, Ms. Alvarez was current on her rent at that time. Is that correct?
At the moment, yes.
And then has Ms. Alvarez paid her April rent yet?
She has not.
So at the time, is there a balance on the ledger for Ms. Alvarez?
There is, including late fees, $892.95.
And are you currently asking the court for an order of possession today because Ms. Alvarez is behind on rent?
Yes.
Okay. Thank you, Your Honor.
How much is the monthly rent?
$875.
And she owes $892, so she owes April rent plus $17.95.
Late fee. She had a credit of $12.05 before the April rent was charged.
Well, again, I'm not gonna evict somebody who is 8 days late on the rent. I'm just not gonna do it. Ms. Alvarez, having said that, eventually you make a habit out of this.
Yes, Your Honor. I'm so aware. Unfortunately, I did have a job at the factory that I was working at, and our machine kept getting messed up and they kept calling me off and calling me off and calling me off. I was only working like 2 hours a night, so I had to get a whole nother job. But I started my
Michael, are you still here? Do you remember once I sent you a GIF or a meme or something where that one girl ate the dandelion puffs? Look at her, Michael.
first day today. I do have my payment schedule here. I had called them on the 6th because per the actual thing that they usually send, if we make an arrangement with them by the 6th, usually they honor that. But then I had spoken to Ken and he said that I was already under eviction, which shouldn't have been the case if communication had been had. I had spoken to him hours before the court date and let him know, hey, I called him, sent him receipts and everything. And then imagine my surprise when I checked my case and the eviction had still gone through. So on my end, I'm a little confused.
Case is gonna be pending. I'm just not gonna enter a possession order at this stage.
Right. And my first check does come in 2 weeks, so I'm able to pay the balance then.
What is the grace period?
Anything after the 5th receives a $10 per day late fee.
Well, you can charge that, but I won't give it to you. Okay, so.
May 6th?
I guess that would be. May 6th.
How did
May
they get
6th for
here?
status by Zoom.
Thank you very much, Your Honor.
Thank you, Your Honor.
It's not gonna go on like that forever.
I know this will be the last time. I
No, it
do
won't.
very
No, it
much apologize. I thought this other job was going to work and it just didn't pan
It won't be
out.
the last time, lady.
Good luck.
I promise you.
Thank you very much, sir.
Thank you.
Thank you, Your Honor.
She's 8 days late today of the hearing. How did they get a hearing? I mean, it takes a while. That's crazy. I just thought that was crazy that they had her in there. She's 8 days late. I want her evicted, Judge. Judge, you gotta evict her. Alright, this is the loud. I can't be late because no one pays me to be here at a certain time. So how can I be late? I make $3 per stream, Brand. I get here whenever I want. this one is the loud judge. And in her court, we have a loud defendant. Or, defendant's not the right word. Plaintiff? Because it's civil.
Runway Ice LLC.
Travis Bargo, Receivers present.
Okay. Good morning, sir. Tell me your name.
Yusuf.
Yusuf what?
Yusuf Onur Uygur.
Okay, great, thanks. Sir, this is your motion. Do you oppose it?
Yes.
Okay, so let me make sure I understand. You are the plaintiff, correct?
Yes, ma'am. Yes, Judge.
Okay, and the defendant is Runway Ice?
Yes, and Mr.
You are
Dag.
the receiver for whom?
Mr. Dag, he is an individual judgment debtor.
Debtor or creditor?
Before you ask me what this guy's about to say, I don't know. I have no idea what he says. It's a lot, though. It keeps going on.
The debtor. Mr. Yusuf is the creditor.
So you were appointed to assist him in collecting against the person who owes him money?
Yes.
And he doesn't want you to help him?
That's my point.
And you're opposing that motion?
Yes. I can explain.
Even though he doesn't want your help?
Yes.
I can't wait to hear the explanation.
Explain.
Go ahead.
Okay. So, in an instance where a receiver's been collecting, oftentimes when you get a request to terminate a receivership, it's because the debtor and the creditor have gotten together to resolve their differences, and they don't want to pay the receiver for the collection efforts associated with the pressure which gives rise to the settlement. It's a little counterintuitive. Maybe that's not the term. It's a little backwards for the person who allegedly has not been paid their debt or hasn't come to terms to then say, I don't want any assistance collecting it. And so, there's a variety of collection methods that you would use in collecting on somebody. Some would be more active in person. Some would be obviously through bank levies. Some of them is continuing to have a receivership out there that makes it more difficult for business owners and individuals to obtain debt financing and such. Those things usually bring that person back to the table, and then you would start negotiating with them.
Okay, so his motion, I've read what you sent to me.
Jude, thank you so much. Thank you.
Says you're doing a bad job. Tell me what you've done.
Certainly. Well, number one, I offered additional replacement receivers, and he wasn't interested in those, which is why the antennas went up. However, to answer your Honor's question, well, with one person and on-site receiving it, we expended the efforts associated with that. I surveilled the house multiple times afterwards. The house was located in Fort Bend County. The house has since been sold. It was a homestead, and as a result, I could not get those funds because they would have been exempt. I had filed a motion to show cause. I had not seen your order, so therefore I wasn't able to get service in time for the show cause hearing. And then the debtor essentially disappeared. I went through probably 9 to 12 different addresses that pop up on his credit report, other services used to locate debtors. Obviously took pictures. You can see where they had moved out. So I had done some work on the file. As far as my communications with the creditor in this instance, I even said, if you've reached an agreement with him, I don't need percentages, just pay me something for my time. I also have some expenses that, I would say are rather minimal. I'd say under $1,000. But nevertheless, these are on full contingency, and you do spend time and expenses on them. And so I had suggested, something, and Mr. Yusuf rejected all of this.
Okay, do you have an invoice?
I do not have an invoice, but I can testify to my time.
Okay. Sir, I'm going to swear you in. Raise your right hand. Do you solemnly, no, you're right. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Okay. Have you resolved your claim with the debtor?
I didn't contact any time with the Matt, and I explained to him, Miss Judge, I contact with the attorney Daniel. I told many times to Mr. Travis contact and apply to you to judge, bring the Matt to court, but he didn't apply. I have the email.
Can I see this?
Yes. He didn't apply. After he said the house, and you can contact with the Daniel here, man. And here the different things. Also,
Okay, you can go ahead and step back. These are all the documents you want to give me.
And this is also.
No, Bren. No. Don't worry, Bren. I got your back. I will have your drink for you. Out of the goodness of my heart, because I never stop giving, I will have your drink for you.
My agreement,
okay.
They don't supposed to want money from me. They want the money from me for the expense.
Okay, but who is the debtor?
The debtor is a gentleman named Matt Dagley, who also goes by Matt Wright. Dagli.
Dagley pay you money?
No, ma'am. No, Mr. No, I never contact, and he didn't pay any money.
All right. Why don't you go ahead and step back?
Although I don't understand what he's saying, I know the gist of what he's trying to say. All right. He is going after some money, okay? And he's owed money. The court appointed this lawyer to go and get him the money. And the lawyer did do work on the case, but didn't do what this guy told him to do. So he doesn't want this lawyer to help him no more. So he's asking the judge to get rid of this lawyer.
All right, go ahead. What else do you want to tell me, sir?
I explained my attorney Daniel and Matt every time escape, and he's supposed to tell the letters to you, Miss Judge, and police enforcement will bring the Matt, but he didn't do this. My idea this to Matt sent the leave to me to make an agreement. I talked to Daniel, and I talked to who sent the news to. I thought Matt doesn't contact with me. He contact attorney.
Who contacted attorney?
No one contact attorney. My son friends to tell the something. Matt wants to make an agreement. I thought I don't want to contact with the Matt. He contact with the Daniel. After to Daniel talked to Mr. Travis, and Mr. Travis went to Matt house. Matt house to his Tesla was charging, and he do this, shut down the electricity, and to take the Tesla, and he doesn't open the electricity. Matt has a disabled kids on the house, and his wife come to court and explain these things. After this, Mr. Travis doesn't do anything at my case. He doesn't apply to Miss Judge to bring to Matt to court. And I wait, I contact with the Daniel, and he didn't do anything. And I talked to Daniel, Mr. Daniel, you don't do anything. Mr. Travis do.
There's been a couple people where YouTube has been glitching for them tonight like that, Linus. Go to Twitch. If Twitch is running fine.
Don't do anything. Plus, on our agreement, I thought I don't have any money. Why you want the money from me for the expense for the Mr. Travis? And I thought to Mr. Travis doesn't do anything. You don't do anything, and please leave from my case. Mr. Daniel tell okay, and first Mr. Travis told me your lawyer contact with me and draft documents, and I don't have the money for the attorney, and I wait. Swear God, Miss Judge, and I wait like 3 months, maybe 4 months, to come to Texas to find the money to apply to these things from here. Mr. Clark helped me. I think he was helping me, and after I applied, I don't have the money, and Mr. Travis, I wait to him for the just one letters. He doesn't write. Can I ask you, Mr. Judge, if he doesn't do anything for the just one letters, 4 months, maybe 3 months, if he doesn't do anything for my case, why he wasted my life? And I thought Mr. Travis leave from my case, and he wants the money. For what? I don't have the money to give him. Plus, he doesn't do anything. I am not sure, maybe 5 months, maybe 6 months. And if you don't do anything from my case, and why you waste my time? And why you want money? I don't have the money to give to him. And for our agreement, first also I talked to Daniel, Mr. Daniel, I don't have the money to give you. I don't have money to give to Mr. Travis. And when you get the money, you take. And after Mr. Daniel told me Mr. Travis wants the money for his expense. I have the email here. I can show you. And I thought he wants to $1,000 from the Daniel, Mr. Daniel, my attorney. I don't have the money to give to them.
Okay. Anything else?
Miss Judge, I don't want to work with Mr. Travis anymore, and I don't have any money to give to him.
Okay, I appreciate that. Tell me, you understand, sir, that you are under oath, right? You are under oath.
Yes, just myself, yes.
You are under oath, and you understand that it is a criminal act to tell me something that is not true.
Yes, everything I swear God is true.
Okay. You have not received any money from this debitor.
No, ma'am. I don't take any money. I can show the bank account.
Okay, no, it's fine. Do you have an agreement with him?
Maybe, Bran. Maybe. Because He's the creditor. He let people borrow the money. So if he will lend me money to open up my own little restaurant, shop, coffee shop, yeah, I'll marry him.
For that person to pay you money?
No, I didn't contact with him and no agreement with him.
When was the last time you talked with that person?
I think last time I'm not sure I saw him like 3 years ago, and the last time he sent the message from the WhatsApp, don't contact with me. If you contact, I give the police report. I can show this message to you. After this, I don't contact with him.
And when was that? About 3 years ago?
I think so. You want to see message?
No. Okay.
Yeah, I think I can get one for $12,000.
Fargo.
That's what it would take.
Judge,
What
if he's,
evidence or facts do you have that supports your belief that they have reached some kind of settlement?
well, because there would be holds in place as a result of things that I file, either in the real property records or alternatively putting it on his credit report.
His mic is
And
fine.
as kind of I stated at the beginning, it's somewhat illogical that he would want someone to stop pursuing his debts for him if he was still owed the money. If he doesn't want to work with me and he doesn't think that I'm doing a good job, okay, then what I suggested to him was coming back to court and having you appoint a replacement receiver. And I know all the receivers. And so all I would say is I have X in expenses, and when you collect something, I had it roundabouts this in time. Okay. And then if they end up getting paid, then hopefully they pay me something. We usually, a lot of times, if that's the case, we will work that out. He doesn't want to do that. So he doesn't want anybody pursuing his debts. Obviously, he's not a lawyer. He's saying he doesn't have the money to pay a lawyer. So as a result of that, he's just writing off the debt. And just out of the kindness of his heart, he's just making the receivership go away. It doesn't make sense. It would appear that he wants the receivership terminated. And then when that's terminated, the debtor's going to know and understand, okay, now I can pay you whatever amount of money after you made this go away. That's what I believe is the case. But
Just, Miss Judge, sorry, I swear God, just I can show the bank account from the Zelle. Just for the $20, I asked my friend. He sent $20. And if am I stupid? Am I not have the honor? If I have the money, I asked the $20 from the Zelle from my friends. And Mr. Judge, you can ask Mr. Daniel. He just write the one letter.
Okay.
And I will just this letter.
Sir, I got it. Okay. Explain to me what harm is there, okay, in allowing him to continue to try?
To cut to him.
What harm is there in just leaving him in place?
Oh, sorry about that, Mr. Judge. Sorry.
That's the question. What harm is there to just leave him in place? The guy might win the lottery and then he gets it.
I didn't understand.
Sure. Is there anything bad that will happen by leaving him as the receiver?
I sent him many mail he just to do one thing, Miss Judge, to send the letters to court, and to court will bring the net with the police enforcement. And he didn't write. I sent him many mail to Daniel, and Daniel told me Mr. Receiver lose his attention to case, and he doesn't write. And he thought he doesn't contact with Mr. Daniel. And I told to him to look, Daniel, to many months, one letters, he cannot write.
Yeah, but here's the thing. He hasn't cost you a thing yet. He has cost you nothing. And if he collects nothing, he gets nothing.
But Miss Judge, he doesn't do anything to my case. He just.
You're not asking me to replace him.
I want to him I don't want to work with him for just one letter. One letter.
I understand that. Sir, I understand that you don't want to work with him.
Yes, ma'am.
But you want me to appoint someone else?
Firstly, I want to leave from him. After I will.
You want me to appoint a different receiver?
Different receiver?
Yes.
I want to think. And first I want to think. First I want to leave from the Mr.
No, you have to answer my question. Do you want me to appoint another receiver?
For to how much I have to pay the new receiver?
As much as you've paid this one, zero.
With which receiver?
And how much money have you paid, Mr. Vargo?
Zero.
Yeah.
Yeah, and I want to learn which receiver.
Okay, I have heard enough. The motion is denied. Get me an order.
Yes, Judge.
I'm denying your motion. Here, you may take these back. Will you, please? Thank you.
Everything is clean?
Yes.
Thank you.
He's confused.
Get me an order today, please.
Yes, Judge.
His receiver's out of there. Bye.
And no more.
No, I denied your motion. He's staying on the case.
Can I ask you one question, Ms. Judge?
No, we're done. It's time to go. Mr. Fargo, you can talk with him out in the hall. Thank you. The next case I have is cause number 20.
We made it to the end and nothing happened. But all right, guys, it was a pretty good stream. This one was a pretty good stream. So I decided if you watch anything on my court disorder channel, if I can get this video done, I'm going to put a 4-hour I'm going to put a 4-hour block of Mr. Kelly on there. Because I found a 4-hour block of Mr. Kelly. And if you don't remember the mason jars, I don't know what to tell you guys. So good. So freaking good. So I might not be able to get it done before I have to go to work today, so it might be a tomorrow thing. But I'm gonna try. But it's if you haven't seen Mr. Kelly, this will be a 4-hour block without me pausing and talking and doing what I do. So so it might be better. If you've already seen it, please don't feel you have to go over there and watch 4 freaking hours. Please, you're fine. You do not have to. I appreciate it though, but you do not have to. And then what is today? Today's Tuesday, so we'll be back tomorrow for 2 streams. You know what? Maybe I'll take 30 minutes of Mr. Kelly, and just 30 minutes. There's no verdict because I looked it up last night, and the cases are still pending. They are still litigating. All right, but there is something interesting. If you remember where we left off, they had this hearing, all right, And Judge Caulfield was going to get through all Mr. Kelly's motions during this hearing. And some of his motions are contempt motions against Mrs. Hitzer, but I can't remember her name. Doesn't matter. His ex-girlfriend. So, it was a throuple. She was married. Her husband became paralyzed from the waist down. So they invited Mr. Kelly into their marriage so that she could have some physical attention from someone. And then they had a baby. 2 babies. So she had 3 kids with her husband. And then while this boyfriend was there, 2 more kids with him. So now they're in this gigantic custody battle over the children. And this guy has sued her lawyer, who she married. So she divorced her husband, married her lawyer, and then got a different lawyer, and he sued him. He sued the police of chief. Figure that one out. He sued Judge Caulfield. He sued the Catholic Church. But if you remember the last hearing, Judge Caulfield was annoyed at Cindy Hetzer because she was being evasive. And he proved flat out that she did not submit the correct video length. It's supposed to be 58 minutes. She submitted 7 minutes. So Judge Caulfield laid into both of them, saying all this is supposed to be for the children, about the children. None of you are making this about the children. You're not being truthful. And he's just a pain. He's completely a pain. Oh my gosh. So he's like, I'm about to roll. I'm going to roll on these motions because you made me, and neither of you are going to like what I'm going to roll. Well, if you look in the case file, right after that was over, boom, they came up with a stipulated agreement for the children. Okay? And so Judge Caulfield did not have to rule on parenting time because they came up with a stipulated agreement. But it's still, I wonder if I can show you this. This is just one of the cases. I'm not even joking. This is crazy. Crazy town. So, let me shrink it a little bit. This is just one of the cases. Let me go to the top so you can see. There's 2 cases open right now, okay? This was, the first filing date was April of 2024. And he's pro se. And he's been incarcerated for contempt of court during this. And filing motions while he's in prison. This is just the one case. This is just the one case. I'm halfway right now. He can't even make this up. He has 2 cases, identical, just as bad. So that's what I'm going to do on court disorder today. If I stop talking and get it done. And I might, Snoop, how was your surgery? I'm so glad you came in here. Oof. Anyway, thank you for coming out. I appreciate it. I will see you tomorrow morning. I hope you all have a great day. All right? Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me with such a groove. I'm It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself.